clients without their knowledge and takes pictures of them. Well, he was sued for that. A combination of the suit and other bad monetary things he made, he was about to file bankruptcy until his cash cow, as he referred to her, walked in. And we have evidence of that, which was never presented in court, okay, under cross-examination or direct examination. He was the extorter. He testified, Coulter, in the trial, that he was basically working for free. I was only going to get 10% of anything of this negotiation he was negotiating to, okay? Well, we have a 12-page document, and I have it here, where he did a 12-page negotiation of all the money he would have gotten. And I think it was, what, $7 million he would have gotten right up front? That was never presented in trial to contradict his testimony. This guy testified and lied under oath, committed perjury, at the direction of the government, that he was working for free. He was a poor soul, a good guy, just trying to help poor Karen Sypher, which we have the information and documentation to show that that is not true. He perjured himself on that. A 12-page document shows that. Her attorney, trial attorney, Jim Earhart, had that document right at his feet in a box and never used that in cross-examination. Never questioned Coulter about that. That's number one. Number two, this whole case spins on a photograph that's supposed to be a photograph of Karen giving oral sex to attorney Coulter. Now this photograph, which is all over the media, this is a family show, we're not going to show it. All you see is the back of someone's head and a torso. You cannot tell who this is in this photograph. Mr. Coulter testified that he took the pictures, it's him and it's her. Well, we have direct evidence to say, A, we have an affidavit, I have it right here, we'll offer it up for the press to see, from a forensic expert that says that that photograph has been tampered with, that that photograph has been manipulated. And we have another witness who will say, it's not him, it's not her, it's probably me, because she was with him on that day. All of this evidence, none of it was presented at her case, at her trial, because her attorney Earhart, who was handpicked by a U of L graduate judge, a U of L law school graduate judge, a judge who has financial investments in the bank, who funded this Yum Center, who was required to disclose all of this and didn't. And then when we caught him on it in our motions, he lied. He said, I don't have any financial things in the Yum Center or in this bank.
Stockyard Bank.
Stockyard Bank. We have the financials. Yes, he does. We have it. This case should have never gone to trial. Had she had an attorney that wasn't playing for the other side, if she had an attorney that was doing her job, this would have never went to trial. He would have had those photographs scientifically evaluated, and the photographs would have been gone. The testimony of Coulter saying, oh, he's just working for free, he's just a poor old guy, just, trying to be her valiant, that's his testimony, would have been gone, okay? He would have never testified. That's 60% of the evidence they had or more in this case. Now we have the other key evidence, which is tape recordings. Supposedly, someone called up a person, as the government is presented, a person called up Rick Pitino and made 3 different phone calls. Threatening, and really the last phone call is really the only threatening phone calls. These are the alleged extortion phone calls. Well, the government coughs up a witness, this Leo Getzinger, who takes the stand, and on 8 different times in his testimony, we have the transcript, he says, it was me, it was me, it was me. All 3 calls were me. Well, had attorney Earhart done his job before the trial, he would have sent these tapes off and he would have had them forensically evaluated, as we have done. What he would have found is, no, it's not him, it's not him, it's not him. Okay? It's at least 2 voices, maybe even 3. That's the key evidence in this case. We have debunked it. We have hard evidence. We have affidavits. We have proof that the key evidence in this case are debunked. They don't exist. These people perjured themselves. And what's more disturbing, the government knew it. The government knew it.
If I might add to this, Darlene touched a bit about the agreement with Coulter and some of the things he was involved in. As of today, I believe it was entered today, it may have been Friday, but we got it today, one or the other. We had become aware of direct evidence that Coulter was destroying evidence and that he was tampering with witnesses. There's a family court order which essentially makes Dana Coulter an agent in fact of the government. He doesn't work for the government directly as an employee, but he's an agent in fact. Kind of like I'm an agent of several attorneys. I work as their agent. And the family court order is right here. I'm not going to use up the time for that, but it basically says that Coulter is working for the government. Here he was under the auspice he was working for Karen. And we filed a motion for emergency restraining order because we needed that stopped. He's destroying photographs, he's destroying computer files. The government's come up with some half-baked argument that they didn't raid Coulter's office, which we've got other evidence they did. And the court went along with that and said they don't have any jurisdiction, essentially. There's no rule that allows them to stop the other side from destroying evidence. It's hard to violate somebody's rights more than to have the government tie your hands behind your back and beat you in the face with a baseball bat by destroying your evidence. And that's what they've done. The court flat denied relief on that in such an egregious situation. This wasn't merely our contention. We presented an email to the court along with my affidavit where the emails came from. That email was very specific that one of the witnesses at trial said in their email to somebody at U of L that Coulter had come to them and had told them how they wanted him to testify in essence. That's in essence what was said. Said he was also deleting files and photographs. Which leads me to the next issue. In Karen's case, the way you got to wonder, how do they get all this information from her own attorneys? Well, the government concocted a scheme. What we found out about Dana Coulter was Coulter has got a history of all kinds of problems. And the court in its findings where they denied a new trial, the court said that here's the problem. The court can't understand how getting the files out of Coulter's computer, even if there were other women on there, would help Karen. Well, if the court doesn't hold a hearing, which they're required to do, but said they weren't required to do, it's awful hard to show the court why that's important. Well, here's why it's important. The other women's pictures in there, we know for a fact that Coulter's computers was ripe with other females that he had done things to. The photographs on their face, you don't need an expert if you look at them close to understand that it's two different women in the picture from Karen to the picture of the woman performing oral sex. There's problems with the clothing, there's problems with the rug underneath her, and there's problems with the hair. It's not the same hair. It's a blonde woman, but it's not the same blonde as Karen's. If that's not bad enough, the way they got all this is, if there was a guilty party here, it would have been Coulter. Because Coulter's own law secretary has come forward and signed an affidavit saying that Karen repeatedly said, I don't want any money. All I want is an apology. I don't want any money. But that seemed to not cut any ice with anybody. Coulter gets up and testifies that he's some Prince Charming, valiant Sir Lancelot who's protecting Karen. Nothing was further from the truth. As Darlene said in Coulter's own 12-page agreement, had Patino paid anything, it was all to be given to Coulter for his control. Every penny of it. The government argued, well, she wanted cars and all these other things. The fact was, Patino took her out with the assistance of her ex-husband, actually took her son out, gave him a car. The son returned the car because he didn't want it because of the way it was obtained. A hearing would have borne this out, but the courts, no, we don't want to hear that kind of thing because it's against the government. But here's the worst part. This came today. The way that this was all admitted in the argument of the government, which the court bought off on, the argument was they didn't raid Coulter's office. That Karen had signed an attorney-client waiver. And that gave the government the right to go into Coulter's office and take whatever they had from Coulter's files. And he voluntarily said, oh, she signed a waiver, here it is. No, that's not how it happened. I want to ask you, Karen, do you remember the day that they kidnapped your child?
Yes, I do.
This was your, what, how old was he?
Jacob was 19 at the time.
Okay. What did you do when you found out that the FBI had abducted your child?
I went straight and called my attorney, Dana Coulter.
Okay, did he take you to another attorney?
Yes, he did that night.
Who was that?
Thomas Clay.
Okay, when you went to Mr. Clay's office, did he ask you to sign papers?
Yes, he did.
Do you know what you signed?
No, I do not.
Would you have signed anything he put in front of you to get your child back?
Absolutely.
Okay. Do you remember the date of that?
April the 14th, 2009.
Okay. I want to show you something here. I'm going to show this to the media, or the best you can, and we'll have to do it after the fact. What I'm holding here is a document I'm going to read. It says, to whom it may concern, the undersigned Karen Sypher hereby waives any attorney-client privilege communications between her and Dana Coulter, attorney, insofar as the Federal Bureau of Investigation seeks to learn about communications between her and Dana Coulter. Karen Sypher further agrees to waive any attorney-client privilege with respect to any documentation in Dana Coulter's possession and expressly agrees to permit Mr. Coulter to provide any such documentation to the Federal Bureau of Investigation. Now, anybody involved in a crime that would be dumb enough to sign this, under the allegations that are going on here, must be crazy. This is dated not April the 14th, but it's dated April the 20th, 2009.
And witnessed by Federal Agent Bauer.
This is, yes, I apologize. This is witnessed by Federal Agent, FBI Agent Bauer, and that's important, and that witness date is also on the 20th of April. Now, I'm here to tell you, ladies and gentlemen, the one thing that we got in the last many days, we got conclusive proof from doctors' offices and other witnesses who are ready to come forward and testify in a hearing that Karen was with them on that entire day and never was at the FBI. And in fact, I believe, isn't this date your son's birthday?
Yes, it is.
Not the one that got kidnapped, is it?
No, he had turned 16 that day, and it was a good day for him.
Now, to go along with this, the FBI has produced where they claim that Karen had signed a waiver to take a polygraph test. Now, the thing that's noticed here is I understand that the examination room does not contain an observation device. With what the FBI did, according to Karen, now that is just according to Karen, wouldn't be acceptable in any polygraph. But what's most important is this document would have come after any waiver of attorney-client privilege. Nobody would argue that. Your attorney would have to waive, or you would have to waive your attorney-client privilege before you took a polygraph. This is dated 3 days before the waiver of attorney-client privilege. But what makes this far worse, we sent this off because a third grader could tell that somebody has cut and pasted Karen's signature on this. We sent it off. Tom Vastrick is arguably the leading forensic handwriting analysis scientist in the world. He's the leader of all these different organizations. Mr. Vastrick sent this to me today. He says, based on the above observations, and we're talking about this FBI consent form, it is concluded that there are classic characteristics present of the questioned signature being the product of signature transfer and not having originated on the consent to interview with polygraph. As such, the signature cannot be authenticated based on the copy provided. What he's talking about here, ladies and gentlemen, and if you look at it, the signature's off the line and much smaller than anything Karen has signed. And I've looked at probably hundreds of her signatures. We noticed this as one of the first problems. It just took a while to get it tested. It's way off the line. The signature below it is not only off the line, but it's cocked. So whoever did the cut and paste did a sloppy job. We're going to ask the court this week to stay again the sentencing and to give us the originals on this. We've asked for the original videotapes because photographs, because we know the photographs are bogus. We've asked for the original voice exemplars because we know they're tampered with. The court, in all scenarios, has said we're not entitled to them. In fact, the court's words were, discovery is now closed. Well, I wonder when justice closes. Somebody asked me why I was going to be here, why I did this. I think Darlene and I have kind of spoken that just because we're willing to endure the harassment that we have to deal with based on these kinds of things. And there's been a lot of harassment of us in this particular case. We've had the best forensic experts there are say that the evidence used in her trial is garbage.
And let me encapsulate what's important about this. A lot of this evidence, when you, again, as a former federal agent, you have what's called a finder. Well, a finder in this evidence is that FBI agent Bauer. He's the one who did the